Welcome everyone to this lecture on multinational corporations and legal human rights accountability, offered in the context of the sector plan on business and human rights. Other lectures in this series have dealt with corporate social responsibility, CSR, and the development of the UN guiding principles on business and human rights, the UNGPs, including by considering how these soft law instruments interact with law. My lecture will look at more recent regulatory developments in Europe that aim to make corporate social responsibilities for human rights legally binding with extraterritorial effect. So-called home state regulation of corporation that intimates a regulatory turn in business and human rights. It is important to note at the outset that this regulatory development takes place against the background of a long history of egregious human rights violations committed by business enterprises at home in the global north to the detriment of workers and local communities in the global south. Among the well-known examples are the Bhopal tragedy of the 1980s, where the explosion of a pesticide factory run by a subsidiary of the US corporation Union Carbide killed or seriously injured thousands of inhabitants of the Indian city of Bhopal. Then there is the execution of the Ogoni 9 in the Nigeria of the 1990s in response to civil unrest caused by Shell's oil drilling and gas flaring operations there. In the 2010s, the collapse of the Rana Plaza building in Dhaka, Bangladesh, where workers produced garments for major retailers in Europe and the United States, and more recently, the adverse impacts of business responses to the COVID-19 pandemic on human and workers' rights in global supply chains. What these cases share in common, other than inflicting serious harm on workers and communities in the global south, is that they illustrate how corporations in the global north have long escaped legal accountability and liability for adverse human rights impacts which they cause or to which they contribute. Thus, what Professor John Ruggie, the author of the UNGPs, referred to as today's business and human rights predicament is not simply the consequence of what he called governance gaps created by globalization. This predicament is equally due to long-standing legal accountability gaps in domestic and international law concerning the prevention and redress of business-related human rights violations. One such accountability gap stems from the public-private divide in international law. The public-private divide has construed powerful for-profit corporations akin to private individuals whose disembodied human rights require protection against the state and whose responsibilities towards society are exhausted by maximizing shareholder value and engaging in corporate philanthropy. At the same time, the state-based domestic-foreign divide has propelled a globalization of the liberal sphere of free market activities, while at the same time constricting the scope of states' human rights obligations by sovereign territorial borders. This territorialization of human rights obligations in public international law, together with the segmentation of globally integrated business enterprises into separate legal persons via domestic private law, the so-called corporate veil, has shielded for-profit corporations from legal human rights accountability. Consider by way of example the Dutch and UK government's response to attempts by Nigerian descendants of the Ogoni Nine to claim damages for human rights violations against Royal Dutch Shell plc in the US Supreme Court. The Dutch and UK's government's policy is that companies should behave with respect for human rights of people in countries where they do business. The governments, however, also believe that the most fair and effective way to achieve progress in this area is through multilateral agreements with other states, and then the effective national implementation of these standards. What are these governments saying here? Well, in a nutshell, yes, they support the idea that companies should respect human rights wherever they operate. And yes, they like international human rights treaties. But no, they don't think that an Anglo-Dutch company should be sued in a United States court for human rights damages in Nigeria. It is for each state to ensure an effective national implementation of international human rights within its sovereign borders, including in relation to corporations that operate on its territory. How does this state-centered view square with the polycentric global governance framework envisaged by the UN Guiding Principles on Business and Human Rights? I assume most of you will be familiar with the three-pillar structure of the UNGPs. Otherwise, I would refer you to some of the other lectures for further background. In essence, there are three pillars, the first pillar being called the state duty to protect against human rights abuses through appropriate policies, regulation, and adjudication. The second pillar addressed to business enterprises that should act with due diligence to avoid infringing on human rights and adverse impacts. In a third pillar that is supposed to bring to victims of corporate-related abuse effective judicial and non-judicial remedies. 3 points are of relevance for our examination of corporate legal human rights accountability here. First, the second pillar impressed upon business enterprises that corporate respect for human rights was neither voluntary, as in previous CSR initiatives, nor was it legally binding, as for example, through domestic labor law. But it was mandated by what John Ruggie called companies' global corporate social license to operate. So it is required, if you wish to say so, by global social expectations towards business enterprises. Secondly, the first pillar, the state duty to protect, constricted the scope of states' human rights obligations to corporate abuse within their territory or jurisdiction, reiterating pretty much the view of the UK and Dutch governments we saw on the previous slide. And third, and possibly because of this combination of territorialized state obligations and legally non-binding corporate human rights responsibilities, the third pillar that focuses on victims' access to effective remedies remains a mess to the present day. As the Human Rights Council emphasized in 2016, at present, accountability and remedy in cases of corporate human rights abuse is often elusive. Human rights impacts caused by business activities give rise to claims of action in many jurisdictions, yet private claims often fail to proceed to judgment, and where a legal remedy is obtained, it frequently does not meet the international standards of adequate, effective, and prompt reparation for harm suffered. Now, what does the more recent regulatory turn in business and human rights in Europe have on offer in terms of closing these protection gaps? Let's start by briefly exploring how so-called home state regulation fits into the three-pillar structure of the UNGPs. Regarding the first pillar, the UNGPs consider that whereas states may not be required in international law to regulate corporate human rights impacts outside their territories, they are at least not prohibited from doing so, provided there's a recognized jurisdictional basis, and indeed there may be strong policy reasons for states to regulate with extraterritorial effect. Regarding the second pillar, the UNGPs did emphasize that corporate human rights due diligence applies to a business enterprise's global operations, irrespective of that enterprise's corporate structure, thus the corporate value problem. Now, home state regulation uses domestic law to impose on business enterprises legal human rights due diligence requirements that reach out into corporate groups and global supply chains. That is, at least in theory, because many existing examples of home state regulation in Europe still fall short of holding corporations legally accountable for their global human rights impacts. The first wave of regulation we've seen aimed at enhancing corporate transparency by imposing reporting and disclosure requirements on global business enterprises. One guiding idea behind this is that reporting requirements would help consumers and investors to better evaluate business practices and thus indirectly encourage companies to take care of their human rights and environmental footprint. Examples of this type of regulation include the EU Non-Financial Reporting Directive and the UK Modern Slavery Act. Now, these attempts to use market incentives to make corporations responsive to human rights challenges by moving from a blame and shame to a know and show model have not been particularly successful to date. One problem is that ultimately companies must do nothing more than reporting what they've done to address the adverse impacts, or indeed what they've failed to do. Another problem is that because reporting requirements aim at swaying consumers and investors, companies' human rights records tend to look much nicer on paper than they do in practice. The second wave of responses to the business and human rights predicament may be referred to as market-based human rights due diligence legislation. Market-based because it imposes human rights due diligence requirements on business enterprises that place products or services on the state's domestic market. Examples here include the EU conflict minerals regulation and the Dutch child labor due diligence law, which has not yet entered into force. There are two main shortcomings, again, of existing examples of regulation in this area. One is that they tend to only apply to specific sectors of economic activity, such as mineral extraction, or particular groups of rights holders, such as children in our example, which contravenes the universality and indivisibility of all human rights. The other shortcoming is that insomuch as market-based human rights due diligence legislation is often justified in virtue of protecting domestic consumers, it does not contain remedies for victims of corporate human rights abuse in the home state or host state of corporate investment. A third modality of home state regulation may be referred to as parent-based human rights due diligence legislation. Parent-based because it does not tie human rights due diligence requirements to market access, but instead imposes them on business enterprises that are domiciled in the home state and then applies them with extraterritorial effect through the corporate group and the supply chain. Examples are the French Duty of Vigilance Law and the German Due Diligence Act of 2021. Now, while parent-based legislation commonly includes cross-sectoral human rights requirements that benefits all groups of rights holders, it currently only applies to comparatively large business enterprises as duty holders. Furthermore, the existing examples tend not to cover the entire value chain. The German Act in particular focuses on direct suppliers and affords protection to workers in lower tiers of the supply chain only under exceptional circumstances. Moreover, the French law is presently the only example to include a civil remedy mechanism that enables foreign victims to sue the parent or controlling company in France for violations of human rights in the supply chain. To drive this short lecture to a conclusion, it is too early to assess the overall contribution of the discussed regulatory turn in business and human rights to ensuring legal accountability of business enterprises for their global human rights impacts. But some common challenges and prospects may already be discerned. As concerns the regulatory shortcomings of existing examples of home state regulation, there's an insufficient coverage of that legislation regarding company size, sectors of economic activity, and groups of rights holders. There's an insufficient protection of victims in the lower tiers of the supply chain because of a focus on primary suppliers or otherwise a tier-based approach. And there's insufficient attention to judicial remedies for victims of corporate human rights abuse. Now, these regulatory challenges tie in with broader normative concerns, specifically concerning the fact that the momentum for home state regulation emerged in the global north. In one sense, this does make sense because many of the major global business enterprises are still at home in Europe and the United States and Northern America. Yet, in another sense, we are dealing here with a modality of unilateral regulation with extraterritorial effect, through which, or this is the concern, home states in Europe may impose their regulatory preferences on states in the global south, sometimes referred to as the problem of market power Europe. Now, this presents a normative dilemma. On the one hand, home state regulation appears necessary to enforce corporate respect for human rights in global supply chains. Yet, on the other hand, there's the concern that this may perpetuate the pro-business status quo in legal regulation and may perpetuate market hegemony in North-South relations. In terms of prospects, well, obviously, one way to address these shortcomings is through better regulation, something that the European Commission is generally speaking very fond of. An example of such a better regulation may be a directive on corporate due diligence and corporate accountability proposed by the European Parliament in 2021. If ever adopted, this directive would include cross-sectoral human rights due diligence requirements that cover the entire supply chain. It would apply to medium and small-sized enterprises under particular conditions, in addition to large companies, and it would ensure judicial remedies for foreign victims of corporate human rights abuse in European member state courts. Further, in terms of prospects, an important complementary way to enhance corporate legal accountability is through strategic litigations, where instead of parliamentary avenues, you use domestic courts to hold companies accountable for their global human rights impacts, as discussed in another lecture. An important example of this being the recent Dutch 4Farmers case against or concerning Shell's oil spills in Nigeria. And finally, and specifically to mitigate concerns that unilateral home state regulation from the global north may simply perpetuate market hegemony in relation to the global south, is the initiative of an international business and human rights treaty currently negotiated in Geneva. Why would this be important? Well, because it would embed unilateral regulation in a multilateral international agreement that includes extraterritorial state obligations to prevent and redress corporate human rights abuse. References to the discussed legislative instruments and some suggestions for further readings are contained on the last two slides. Thank you for your attention.